Testing, 1, 2, 3. Testing, 1, 2, 3. Hello, hello. Testing, 1, 2, 3.
Thank you.
Can you hear me? Okay.
Good morning, everyone. We're going to start today with the case 24-2794, 37 Celsius Capital Partners versus Intel Corporation. We will hear from the appellant.
Good morning. May it please the court. My name is Gabriel Grayheck, and I represent 37 Celsius, the plaintiff appellant in this case. In our opening brief, 37 Celsius states a number of points, all of which we believe merit your attention. But the utterly decisive one, and the one that I would like to address first, is the fact that the term sheet signed between the parties is a Type 2 agreement under Delaware law. When New York federal courts first developed this framework for analyzing preliminary agreements, they distinguish between two different types. The first type occurs where the parties have reached a complete agreement on all major terms, including the agreement to be bound. It merely contemplates memorializing a more polished form or a formal document at a later date. The second type, and what we have here, is a Type 2 agreement. It expresses mutual commitment to a contract on agreed major terms.
Counsel, it's with regard to determining whether an agreement is a Type 1 agreement, Type 2 agreement, or none of the above, is there any one dispositive factor, or are we to consider the entire agreement and read it in its totality?
You have to read the entire agreement and read it in its totality. The most important thing is that the parties have to agree to negotiate. And the parties here agreed to negotiate, and they even went a step further. They agreed to negotiate exclusively. And the district court erred in its determination that the term sheet was not a Type 2 agreement.
But just so I understand, the exclusivity agreement is not what makes this a Type 2 agreement. Is that correct?
That's correct.
So it is some, according to your client, what makes this a Type 2 agreement is some agreement to continue negotiating in good faith to the final agreement.
Correct. And it's important to note that a number of the major terms were already agreed to. The parties laid out a detailed framework for a final transaction by which 37 Celsius would acquire a 70% ownership stake in CARE for an investment of $12 million. The Intel would retain 15%, and 15% would be reserved for future stock options or equity bonuses. But to return to the district court's finding, the district court erred because it stated that there was no express agreement to negotiate in good faith. But the absence of a good faith provision is no impediment to the formulation or the formation of a Type 2 contract. To be sure, Type 2 agreements, they do sometimes acknowledge that the parties wish to state in definitive terms that they agree to a duty to negotiate in good faith. But while that express good faith clause is a relevant factor in identifying a Type 2 agreement, it might even be a sufficient factor to create a Type 2 agreement. It's not a necessary factor.
So if we are to look at the entire agreement, I'm talking about the term sheet now. And the exclusivity provision is not what gives rise to your client's argument that this is a Type 2 agreement. What are we to do with the language in the no binding agreement paragraph that, quote, neither this term sheet nor its acceptance shall give rise to any legally binding or enforceable obligation on any party except with regard to, and it notes specific sections, including the exclusivity section. That seems to be a express disclaimer of any other legal obligation other than those expressly enumerated. And so I was wondering what your response to that is.
Well, it's important to realize where a preliminary agreement is in the negotiating stage. And it's not uncommon for preliminary agreements to contain non-binding terms. The term sheet in SIGA, for example, contained a non-binding provision. So did the term sheet in Cambridge Capital. The non-binding terms specify that this agreement can't be used to enforce the final transaction, namely the closing of the transaction between Intel and 37 Celsius. But those binding provisions, and in the term sheet, the binding provisions outlined were the governing law provision, the third-party beneficiary provision, the confidentiality, and the exclusivity provision. So the parties did agree to be bound by this exclusivity provision in the term sheet.
But that's, I guess, I understand your point. I guess my concern is that the confidentiality, the exclusivity, governing law, third-party beneficiaries, those refer to provisions in the term sheet, not provisions in some future agreement. And so I wonder whether in context that provides additional meaning to, or at least explains what the parties intended when they say that other than those, the document gives rise, that is the term sheet, gives rise to no other legally binding or enforceable obligation.
Well, that's precisely the point. Here, Intel breached the exclusivity provision that the parties agreed to be bound by. And the exclusivity provision specified that Intel would solely negotiate with 37 Celsius for the closure of care.
But I thought you said that the exclusivity agreement is not what gives rise to the good faith obligation on which you're relying on this case.
The exclusivity clause gives rise to the breaching the exclusivity clause is a component of the breach. The breach here, let me restate, the breach here was where Intel negotiated outside of the exclusivity clause with a company named IC. Every Type 2 agreement carries with it a duty or an obligation to negotiate in good faith, whether or not that Type 2 agreement specifies that it's non-binding on specific terms. If we look at the term sheet in SIGA, for example, that also contained a non-binding clause.
I understand. I guess I'm trying to, in my mind, distinguish between, and you can correct me if I'm wrong, but distinguish between a breach of the exclusivity agreement and a breach of the agreement to negotiate in good faith to a final agreement. It seems to me that those two, while related, they're separate legal obligations, separate breaches. The breach of the exclusivity provision, perhaps or perhaps not, being limited to reliance damages versus expectation damages, which what your client is seeking. And so that's where I think the briefing sometimes gets muddled, and understandably so, with regard to the obligations under the exclusivity provision and the, I would say, for lack of a better word, implied duty of good faith negotiation. But it seems to me that those are two separate obligations. Am I wrong about that?
I think the court needs to look at the SIGA and the Cambridge Capital cases. Both of those cases contain non-binding provisions.
No, but I'm not talking about non-binding provision. I'm talking about whether the obligations under the exclusivity provision are separate, independent from, separately and independently enforceable or actionable compared to the obligation under the implied duty of good faith to negotiate to a final agreement.
They are separate, Your Honor, and the exclusivity provision isn't in every single Type 2 agreement, okay. But a duty or an obligation to negotiate in good faith is in every Type 2 agreement.
So a breach of the exclusivity provision in and of itself doesn't get you where you want to go, which is expectation damages. At least that's not what you're relying upon, right, for the expectation damages.
Well, it's certainly a large part, and breaching that...
No, I understand, but that in and of itself is not what you're relying upon to seek expectation damages. It's the other breach. It's breaching the exclusivity provision within the context of this overall obligation to negotiate.
It is not the sole. So the breach of the obligation to negotiate in good faith isn't the sole aspect or factor that determines that Intel breached this agreement, but it is the breach of that duty that gives rise to expectation damages. And the breach of the exclusivity clause is Intel's breach of the obligation to negotiate in good faith. And that the exclusivity clause specifies that it will only be negotiating with 37 Celsius. It won't accept offers from other companies, and it won't close on a transaction with other companies, all of which it did by March 1st. And
Counsel, why doesn't any such duty end when your clients don't come up with the funds prior to the agreed upon closing date, and Intel sends a notice saying it shall not close?
The letter from Intel only noted that the closing event shall not occur. And I think this is important. The district court used the termination provision to distinguish this contract from other Type 2 contracts. But that's in error. The other contract or other Type 2 agreements also contain termination provisions. What SIGA specified is that a company, as a party to a Type 2 agreement, can't arbitrarily denounce the deal and back away from that deal. But that's not what's in the term sheet. The term sheet outlines 3 specific ways that Intel could have backed out of this deal. Number 1, it could have closed on a final transaction with 37 Celsius, which it didn't do. It could have had written termination or a written agreement to terminate the term sheet between Intel and 37 Celsius, which it didn't do. And the third option is that it could have delivered written notice of termination to 37 Celsius, terminating the deal, which it also didn't do. And that letter only identified that that closing event specified on February 14th was not going to occur. After that date, Intel continued to negotiate with 37 Celsius in direct contradiction to what they've claimed that letter was. So at no point was there any termination of this term sheet. And so the binding exclusivity provision, duty, the obligation to negotiate in good faith continued until they had closed and eventually breached with IC on March 1st.
But the specific term of the closing date didn't apply.
Correct. The specific term of the closing date was not one of those binding provisions. And I think that gives credit to the fact that that termination, or the letter, did not terminate the term sheet between the two parties. And after that February 14th, even though that date was outlined within the term sheet, because it's not in the binding provisions, it can't be enforced as a deadline or a termination date or anything like that.
Did 37 Celsius actually have the necessary funds by February 14th?
Well, 37 Celsius didn't have the necessary funds by February 14th, but it is a disputed fact whether or not they would have had those funds at a later date. And the district court erred in determining on summary judgment. Let me back up one step. The district court determined that the termination provision, a contractual interpretation, precluded it from finding that 37 Celsius could have closed on the deal between February 14th and March 1st or at a later date. But that's a contractual interpretation. There's still a material disputed fact here that shouldn't have been dealt with on summary judgment, that 37 Celsius could have closed. There is evidence in the record that accounting for the funds already gained or the funds already committed to 37 Celsius and Alexander Kempe's own funds, that he could have closed on this deal at a later date. But again, that's a material fact distinction that should not have been dealt with on summary judgment. And I'd like to return to the district court's holding on its motion for reconsideration. And I'd like to quote just one section because I think it really distinguishes the fact that the district court erred here. And it's stated that above all, it's unclear that Cox holds, as 37 Celsius argues that it does, that the absence of an express good faith provision is no impediment to the formation of a Type 2 contract. But that directly contradicts what the court in Cox stated, and it directly contradicts what the courts in Delaware how the Delaware courts have applied Cox since that decision, specifically in the Green Tech Consultancy Company case. In that case, it stated, quote, the agreement in Cox Communications similarly did not contain an obligation of good faith. Still, the Supreme Court recognized it as a Type 2 preliminary agreement. The lack of an express good faith obligation therefore does not hinder this court's conclusion that the term sheet is a type 2 preliminary agreement. I think that goes in direct contradiction to what the district court stated, and I think that this court can reverse and remand on that basis alone.
Can you address the hold harmless provision in the non-disclosure agreement?
The hold harmless provision in the non-disclosure agreement merely applied to the non-disclosure agreement. So the hold harmless clause states that under no circumstances will either party be liable to the other for any costs or damages of any kind in connection with not moving forward to the conclusions of the discussions or negotiations. Now, the hold harmless clause in a non-disclosure agreement only applies to the disclosure of private or privileged information within the non-disclosure agreement itself. When Intel and 37 Celsius later stated that the term sheet was subject to the NDA.
But that's not what the language seems to indicate. The language seems very broad, right? Like under no circumstances will either party be liable to another for any costs or damages in connection with not moving forward to the conclusion of the discussions or litigation or negotiation. It doesn't say in connection with the breach of the non-disclosure agreement or the improper disclosure of any confidential information.
Well, the term sheet only mentions or only refers to the non-disclosure agreement within the confidentiality section of the term sheet. And so that when the parties agreed to the term sheet, they agreed that it is subject to the non-disclosure agreement, meaning the agreement itself is confidential, but it doesn't then incorporate all the limitations of the previous non-disclosure agreement into the term sheet. And the most important point, that the NDA is explicitly limited in its reach. Yeah, under Section 13E, any other agreements between the parties, including the non-disclosure agreements, will not be affected by this agreement. In the non-disclosure agreement, the parties agreed that Intel and 37 Celsius agreed to the non-disclosure agreement, agreed to non-disclosure of private or privileged information to the public, but subsequent agreements would not be affected by the non-disclosure agreement.
Is that what that provision really means? Because it's in the context of the integration clause, right, 13E, and when it says any other agreements between the parties, does it mean any existing agreements won't be affected by this agreement? Or I guess you're reading it to mean any future agreements. And where does that reading come from?
Any future agreements, it's specifically in that Section 13E, that any other agreements between the parties will not be affected, including other non-disclosure agreements. Your Honors, I do want to answer all your questions, but I do wish to reserve the rest of my time for rebuttal.
I'll give you enough time. You can go and answer the question.
The non-disclosure agreement specifies that it won't affect future agreements, and I think that the court should look at the term sheet for the provision that the confidentiality section refers to the non-disclosure agreement as a confidentiality agreement. It doesn't refer to it as a previous agreement. It refers to it as a confidentiality agreement. So that release of private or privileged information should be subject to the non-disclosure agreement, not the incorporation of all limits of liability from the NDA or any previous agreement.
Thank you, counsel. Mr. Grayheck, we'll give you 4 minutes on rebuttal. All right. Now we hear from the appellees. Mr. Splitek?
Splitek, yes.
Splitek.
Good morning. I'm Matt Splitek here for Intel Corporation and Care Innovations, LLC. 37 Celsius cannot recover damages that it waived to compensate for the value of a transaction that it had no right or even ability to close. 37 Celsius was a private equity fund represented by 2 elite law firms, and it began its negotiations with Intel by explicitly waiving Intel's potential liability for lost profits if the negotiations did not result in a deal. 2 weeks later, it then accepted a term sheet in which Intel did not assume any obligation to negotiate a final agreement with 37 Celsius and instead explicitly reserved its right to pull the plug after only 2 days. When Intel nonetheless stood ready to close the transaction on the term sheet's closing deadline, it turned out that 37 Celsius did not have the money anyway. And now here, 37 Celsius not only wants to be paid as if it did close the transaction that it did not have the money to close, it wants access to the exact same damages remedy that it waived at the outset of its discussions.
Mr. Splitek,
yes.
preliminary question. There was some discussion today about whether or not Intel's letter terminated the term sheet, the letter that says closing shall not occur. I understand that for the purposes of the summary judgment motions, Intel admitted that that letter did not terminate, or that it did not terminate the term sheet. And I guess I'm referring to it's docket 42, paragraphs 27, 23. Is that correct?
Your Honor, it is partially correct because there were 2 motions for summary judgment. So for purposes of the initial motion for partial summary judgment solely on the lost profits claim, Intel conceded that for purposes of that motion. But in the district court's September 2024 decision, the district court held that Intel did terminate the term sheet by written notice, and the district court can be affirmed on simply on the basis of waiver on that particular issue, because in its opening brief, 37 Celsius did not develop an argument in support of reversing the district court's September 2024 ruling that Intel terminated the term sheet and therefore did not breach the term sheet when it sold care to iSeed.
So you're saying that Intel assumed for the purposes of the first summary judgment motion that it did not terminate the term sheet, but for the second one, that was an issue that was disputed and up for grabs?
Yes, in the second motion, one of our primary arguments was that Intel terminated the term sheet, and the district court agreed with us. I want to go to the type 2 issue because it took up a lot of the airtime during the first session. To determine whether the term sheet imposed an obligation on Intel to negotiate a final agreement with 37 Celsius, which is the first of SIGA's 2 requirements, the court must look only to the 4 binding provisions of the term sheet, as Judge Lee, I think you indicated to some extent. On pages 29 and 30 and footnote 9 of our answering brief, we cite different cases that gave effect to parties' decisions to designate which provisions are binding and which are not. The Brown v. Cara case that 37 Celsius relies on page 157 of that decision, also held that a court must enforce a preliminary agreement only to the extent that the parties intended to be binding. So only the 4 binding provisions are on the table, and none of them imposed an obligation on either 37 Celsius or Intel to negotiate a final agreement in good faith or otherwise. My colleague talked about the non-binding footer in SIGA. I disagree with that characterization. If the court looks at pages 345 and 346 of SIGA, the SIGA court dealt with that issue explicitly, and it said that although the term sheet, it called it the lance, is not signed and contains a footer on each page stating non-binding terms, the record supports the Vice Chancellor's factual conclusion that incorporation of the lance, the term sheet, into the bridge loan and merger agreements, which are both fully binding agreements, reflects an intent onto the part of both parties to negotiate toward a license agreement with economic terms substantially similar to the terms of the term sheet. And in those fully binding agreements, the parties in SIGA, they explicitly agreed to negotiate in good faith in accordance with that term sheet. They made that binding commitment that is absent in the term sheet here. So the SIGA court identified the non-binding footer as very much an obstacle that was overcome by the fact that the parties had reached their agreement in fully binding agreements. The SIGA court would not have held for Pharmathene if the only preliminary document on the table had been the non-binding term sheet itself. I also disagree with the characterization of Cambridge Capital. If the court looks at pages 443 through 445 of that decision, the Cambridge Capital Court was very specific in analyzing the terms of the no binding provision. In that case, it found it to be very weak. It specifically contrasted the no binding provision in that case with a provision that disclaims any obligation. And even finding the no binding provision in that case to be very weak on pages 446 and 448, the Cambridge Capital Court, all it held was that the agreement was ambiguous and it could plausibly be read to be a type 2 preliminary agreement at the motion to dismiss phase. Here, we have exactly the language that was lacking in Cambridge Capital. The court also already pointed my colleague to the no binding agreement section. In addition, there is the no reliance section of the term sheet, and there, after in the no binding agreement section, disclaiming any legally binding or enforceable obligation except in the 4 binding provisions. In the no reliance section, they also disclaimed any legal obligation of any kind whatsoever regarding any transaction except for the matters specifically agreed to in this term sheet. The disclaimers could not be more clear, and that distinguishes this case quite easily from Cambridge Capital. And lastly, regarding Cambridge Capital, I will point out, as we did in our answering brief, in the second Cambridge Capital decision, the Cambridge Capital concluded that expectation damages were not available anyway, because putting expectation damages on the table would violate the parties' reasonable expectations ex ante. That decision in Cambridge Capital aligns with one of the district court's rulings here, and 37 Celsius in its reply did not reply to our argument in our answering brief that the district court correctly ruled that even setting aside all the other arguments on the type 2 preliminary agreement issue, the term sheet cannot be deemed a type 2 agreement because it would violate the parties' reasonable expectations ex ante.
Mr. Splitak, one of the provisions that appellant cites to in the term sheet is the language under timing section, right? Quote, the parties will work to close the transaction as quickly as possible after signing, subject solely to the receipt of a third-party consent set forth in Exhibit B. According to 37 Celsius, that evidences an intent for the parties to work in good faith to close the transaction. How do you respond to that argument?
It evidences, Your Honor, that provision is non-binding. It is explicitly non-binding, and 37 Celsius and Intel's decision to make it explicitly not binding evidences their intent to not bind themselves to any obligation stated in those words. The fact that those words appear in explicitly non-binding provisions supports us, not 37 Celsius. It would have, having written those sentences in the term sheet, if 37 Celsius and Intel wanted to commit themselves to obligations in those provisions, all they had to do was add the title of that section to the no binding agreement section, to the list of sections that would be binding. And they did not do that because they did not intend to assume any obligation to negotiate a final agreement.
Well, I guess I understand that argument. But the other non-binding provisions, the proposed transactions, the contribution of each company, the cash contributions, equity contributions, forgiveness of debt, those are all terms that the parties kind of loosely envision would frame the final right document. So they're what I would call kind of forward-looking provisions, right? The timing provision, though, isn't really forward-looking, right? It talks about what the parties are going to do now. That is, the parties will work to close the transaction as quickly as possible. Your argument seems to be that even if Intel completely disregarded that obligation, that 37 Celsius, that basically that obligation is meaningless given the language in the non-binding provision. And is that the position that Intel is taking, that whatever words are in the timing provision that talks about what the parties are going to do now, that it was just kind of, I don't know, meaningless?
I would not call it meaningless, Your Honor.
Well, then how is it meaningful?
Because it expressed the parties' intent while at the same time the parties were deciding that it would not give rise to any enforceable obligations. So it was, I would say that it is not, that language is not enforceable, and that was clearly their intent. But I wouldn't go so far as meaningless, because it was their intent, and
Well, I mean, it's legally meaningless.
I will go that far. And we know that it was Intel's intent because on February 14th, Intel was the one who was ready to close this deal. 37 Celsius wasn't. Before I move on from the Type 2 issue, it's not just that Intel assumed no obligation to negotiate a final agreement. It expressly reserved its right to terminate the term sheet after only 2 days. Also, in the confidentiality provision, which is binding, as the court was discussing earlier with my colleague, it states that the NDA would continue in full force and effect. Giving full force and effect to the NDA does necessarily mean giving effect to the NDA's hold harmless provision. And in Section 9A of that provision, Intel and 37 Celsius each reserved their right to terminate the negotiations at any time and for any reason or for no reason at all. Between that and the 2-day termination provision that Intel had, the term sheet had easy off-ramps that are not present in any of the cases that 37 Celsius relies on. No court has ever made a Type 2 preliminary agreement out of a preliminary document that in this fashion allowed the parties to walk away almost immediately, and in addition included no binding obligation to negotiate a final agreement.
For the purposes of the appeal, is Intel, and for the appeal only and for the summary judgment motions, is Intel admitting that CARE and its agents violated the exclusivity provision?
So, Your Honor, of course, I think you're referring to emails, a few emails amongst CARE employees, not Intel employees. We, of course, don't concede that those communications rose to the level of a breach, but for purposes of this appeal, the court can assume that there was some breach of the term sheet's exclusivity provision between February 1st and February 14th, which is before Intel issued its notice. And of course, it is undisputed that on February 14th, regardless of what had or had not happened before, what CARE employees said in emails, Intel tried to close the transaction with 37 Celsius. I also disagree with the characterization that there is any dispute in the record as to whether 37 Celsius had or one day would have had the money to close the deal with Intel. 37 Celsius did not have the $12 million that it needed when Intel tried to close the transaction. It also did not have the money later. When Intel sold CARE to iSeed on March 1st, 37 Celsius had known for 2 weeks that it was in a race with iSeed, because the record shows that 37 Celsius knew full well that Intel was negotiating with another party, not exclusively with 37 Celsius. And after those 2 weeks, 37 Celsius was not even trying to raise the $12 million that the term sheet called for. As the undisputed facts showed, it had turned to asking Intel to agree to a completely different deal than what was described in the term sheet, under which 37 Celsius would have brought only $6.5 million in cash to the closing, and 37 Celsius wanted CARE to go out and borrow millions of dollars from a third-party lender that 37 Celsius was connecting with CARE in order to access the millions of dollars of capital that 37 Celsius was no longer even planning to bring to the table. So it is undisputed that 37 Celsius did not have the $12 million and wasn't even trying to get it on March 1st when Intel sold CARE to a party that did have the money. And there is nothing but speculation in the record to suggest that 37 Celsius ever would have had the $12 million. All there is written testimony from Alexander Kepi that he believes that he could have gotten the money together at some point, accounting for his personal funds. That does not suffice to survive summary judgment, nor did Intel, even assuming that 37 Celsius had been right in how it characterized the term sheet. Intel, in any event, because of the termination provision, had no obligation under any circumstances to wait and wait for 37 Celsius to finally cobble together the money that it had told Intel it had at the outset. I'd like to address the NDA in the last 2 minutes I have. The plain text of Section 9B in the hold harmless provision applies here because it bars Intel's potential liability for lost profits in connection with not moving forward to a conclusion of the negotiations with 37 Celsius. And nothing in the term sheet prevents that plain text from being enforced. 37 Celsius told the district court in its summary judgment filings in 2024 that the NDA was incorporated into the term sheet. But we don't even need the NDA to be incorporated into the term sheet. The NDA is its own freestanding contract. We just need its plain text to be enforced, and nothing in the term sheet tells the court to do otherwise, because nowhere in the term sheet did 37 Celsius and Intel agree to authorize the damages that they had waived only 2 weeks before, when 37 Celsius signed the NDA. And instead of trying to undo any part of the NDA, in the term sheet, the parties agreed that the NDA would continue, again, in full force and effect, which would be very much the wrong language to use if the parties had wanted to repeal part of the NDA while allowing only its confidentiality provisions to take effect. 37 Celsius's arguments, they cannot be reconciled with the full force and effect language in the term sheet, and more importantly, they cannot be reconciled with the no circumstances, the under no circumstances language in Section 9B of the NDA, which makes it very clear that the parties were not talking about waiving damages solely for breach of the NDA. They agreed to waive the damages that they described under any circumstances. I've reached the end of my time. I'm happy to answer other questions if there are any.
Thank you, counsel.
And I ask this court to affirm. Thank you very much.
Mr. Grahak, I'll give you 4 minutes.
Thank you, Your Honor. I would like to return to the SIGA decision, specifically the obligation to negotiate in good faith. SIGA states that an express contractual obligation to negotiate in good faith is binding. Subsequent Delaware court decisions, Cox, Green Tech Consultancy Company make clear that this doesn't require the use of the terms good faith. You need to expressly agree to negotiate, or in this case, negotiate exclusively. Parties can state that agreement in various ways. The good faith part doesn't need to be said in those words. In that sense, it's implied. But the agreement to negotiate within an agreed framework, like the parties had here, is expressly laid out in a term sheet or a letter of intent. That agreement is not implied. This is separate from implied covenants. The duty or the covenant to negotiate is express. And in that sense, every single Type 2 agreement carries with it the obligation to negotiate in good faith. Regarding the NDA and its hold harmless clause, I would like to return again to the fact that the term sheet signed between the parties only references it in the confidentiality section. A plain and rational reading of the NDA only extends the NDA to private or privileged information. What is a non-disclosure agreement other than an agreement not to disclose private or privileged information? So when the term sheet references that NDA within its confidentiality section, it's merely agreeing that this agreement is confidential. This agreement is subject to the NDA, but it doesn't incorporate all of the limits of liability or all of the other terms into the NDA. If, for example, Intel and 37 Celsius were to agree on a final transaction and it stated that it was still subject to the NDA would then prohibit all damages under that scenario. The term sheet here expressly incorporates an obligation to negotiate in good faith. That obligation extends to the exclusivity clause between the parties, where the parties agreed to exclusively negotiate with each other, and Intel specifically agreed not to come to a final transaction with another party that would prohibit it from closing on 37 Celsius. And I think it's also important to note from my colleague's argument that there's a distinction here between a Type 1 and a Type 2 agreement. The hold harmless clause, even if it were incorporated, which it is not, but even if it were, it limits itself between 37 Celsius and Intel upon the completion of a final transaction. This is a Type 2 agreement. We're talking about the obligation to negotiate in good faith, not the closing of the final agreement. Here this court should reverse and remand based on the fact that this is a Type 2 agreement that carries an obligation to negotiate in good faith. Intel breached that obligation to negotiate in good faith. It also breached the exclusivity clause under the exclusivity provision in agreeing or negotiating to a deal with iSeed, and then finally the final transaction on March 1st with iSeed. We'd ask that you reverse and remand for a further factual finding that 37 Celsius could have closed on this deal and that expectation damages are available.
Thank you, counsel. The case will be taken under advisement. We will now proceed to our second case, case number 242838, 3240, and 1450, Cordeleone versus Arnold. Mr. Bartow, whenever you're ready. No rush. Wait till everyone gets settled in. All right, very good. Go ahead.
Good morning, and may it please the court. The Eighth Amendment is not a medical code that strips policies of the makers of their traditional authority to resolve disagreements. What it prohibits is deliberate indifference or the wanton infliction of pain. So a prisoner cannot make out an Eighth Amendment claim where there is a disagreement or uncertainty. In this case, we have the uncertainty and disagreement at two levels. First, there's ongoing debate over WPATH's stance that surgery is the answer for gender dysphoria.
Mr. Bardo, with regard to that, I know that there's a lot of ink spilled in the briefs and the amicus briefs with regard to the WPATH standards and their and what weight should be given to them. But we're talking about a preliminary injunction order here. We're talking about a district court that's limited to the record before it. And on that record, the district court made a factual finding that the WPATH standards represent widespread consensus in the medical profession. We review that for clear error, which is obviously a very deferential standard to the district court. Why should we review that under, or should we review that under any other standard, and if so, why?
So I two responses, Your Honor. So I think the district court's primary error was not a factual finding, but assessing this under the wrong legal standard. The question is not just, do most physicians recommend a particular course of action? Is it widely accepted? It's is there no disagreement? And I don't think the district court made that finding, and this turns to the second part of the answer. If it had, that would have been clear error. And I think there's a couple of categories of evidence that the district court didn't address that show that. So first,
that show what? I'm sorry.
That preclude any finding that there's no debate about.
Well, but do you? I guess that's the other thing. The question I had was, you talk about in your brief you referred to a no minimally competent professional standard, and kind of tracking that down. At least based upon my research, that seems to start at this case, Colligan versus Milwaukee County, where there we equated that standard with the absence of professional judgment. And so here it seems like you're using that standard, no minimally competent professional, to say that as long as there's one competent professional in the world that would disagree with it, then there could be no deliberate indifference. But is that the right standard? Because even in Gibson, the Fifth Circuit said, universal acceptance does not require unanimity. Here it seems like you're requiring unanimity. Is that consistent with the substantial departure standard that the Supreme Court has articulated in these types of cases?
Well, I think what all of these different formulations are getting at bottom is that deliberate indifference is a subjective standard that requires something approaching total unconcern for a prisoner's welfare.
Right, and I'm just trying to burrow down, because on this kind of no minimally competent professional standard that the briefs keep going back to, and again, the briefs kind of interpret that as saying that there has to be, it seems to me, the briefs are suggesting there has to be unanimity. In other words, every competent professional in the world has to agree that the WPATH standards should control these types of factual situations. But I wonder, where do you find, can you point me to any authority that either in the Supreme Court or factually in our cases that have said that you need such unanimity?
Well, I think, Your Honor, what is a fairly common fact pattern in this court's cases is you have two physicians. You may have an expert hired by the plaintiff and then a defendant physician who have different opinions about how a prisoner should be treated. Wilson versus Adams is one example of that, and that usually defeats an Eighth Amendment claim. And I think that's because it is ultimately a subjective standard. And so if the treating physician in those cases exercise professional judgment, it may be bad judgment, it may be malpractice, but it's not an Eighth Amendment violation. And so, and really what they come down to is the physician says, I don't care about this prisoner. When we're talking about the legislature...
But counsel, we've gone further in our case law. And if I'm understanding Indiana law correctly, a medical professional can't make an independent judgment that gender-affirming surgery is medically necessary. And if I'm right, how do you square that with Roe versus Aaliyah?
So I think you're right that about what the statute requires, but that's where I think looking to the broader debate is so important, because when we're evaluating a legislative decision, we have to start with the assumption the legislature acted in good faith. And so the question becomes, is there evidence to show that the legislature acted in good faith, as opposed to saying just, we don't care about prisoners? And here there's abundant evidence of that. There's the medical literature where you have the federal government in its own assessment of surgery saying the clinical evidence is inconclusive. You have Brandstrom saying that the effective interventions on long-term mental health is largely unknown, and that there is a lack of sufficient evidence to provide, or lack of sufficient knowledge to provide evidence-based recommendations. Alsman saying that the mental health effects of ginger...
Okay, counsel, let me ask you this. Let's assume, hypothetically speaking, let's not talk about WPATH, let's talk about, I don't know, other standards, right? Standard Q, let's say. And there is widespread agreement in the medical community, not universal agreement, but widespread agreement, that standard Q is what is acceptable professional practice, okay? Those are the professional standards. But there are some competent professionals that disagree. In your mind, can a legislature, in the face of that record, say, you know what, we're going to take the side of the, the minority group of professionals, and we're going to impose a complete ban on those types of procedures? Does the Eighth Amendment allow that?
I think it does, Your Honor, and that's precisely...
And so let's take, let's take cancer of some sort, and there's chemotherapy, and let's say there's widespread acknowledgement that this type of chemotherapy is effective and necessary to treat this particular type of cancer. But there's, some good faith disagreement. There are, a handful of experts that agree otherwise. In that case, the legislature can say, you know what, we don't care about all of this other stuff. We think that as a policy matter, we are going to take the side of this other minority group of physicians, and as a complete ban, we're going to foreclose any independent or individual determination, and we're going to say that that type of chemotherapy is not allowed in our prisons. I take it that's your position, that the legislature has the authority to do that.
Yes, but I think what is important to note, the caveat that comes, if there's a minority perspective that is saying instead of chemotherapy, we recommend something different like radiation, then there is the obligation to do something. We're not taking the position that the legislature can just say no treatment whatsoever, and we're very far from that here. And I think, to speak more directly to your question, Judge Kohler, about Roe, I think the difference there is that the evidence showed, or at least suggested on summary judgment, that there wasn't actually an exercise of professional judgment. Instead, the prison adopted a policy to just, as they said, keep it simple. They acknowledged that for some subset of prisoners, the drugs were necessary, but they just decided not to do it. Now
so
here,
where would the independent medical judgment be here?
So I think the problem with the policy in Roe was that there was no judgment being exercised in the creation of the policy. Where the judgment was being exercised here is at the legislative level, saying there is ongoing disagreement over these surgeries, and we are making a determination that these surgeries should not be provided. We're not, of course, the legislature, of course, did not foreclose alternative methods of addressing gender dysphoria, including psychotherapy, including through hormones, including through sort of social support. Instead, what it targeted was what remains the most controversial intervention, which is irreversible surgery.
And for you to defend that statute here, and in this context, and as Judge Lee noted, in the preliminary injunction context, one of the factors the court's going to be looking at is the likely success on the merits. And you could either show, hey, that was a correct judgment, and there's no Eighth Amendment violation, because this procedure is never medically necessary. Or you could have shown this procedure was not medically necessary for the plaintiff. We're in clear error on some factual findings, and where do you get there on this record on either of those two?
So I think the critical one is that the standard is there's no genuine debate. And if we're talking about the legislative determination, even if you just look no further than the medical literature, it's littered with some of the statements I was describing earlier. And even Oltzman said, quote, "The mental health effects of gender-affirming surgery thus remain controversial." I think that's clear evidence there is ongoing debate.
But
Now,
I think I'm getting back to what Kohler was saying. I mean, perhaps as this case continues, that argument, that those facts can come up in discovery, and there may be expert testimony, and the court will have to balance that. And perhaps in the end of the case, after additional discovery, the court may come to another conclusion that WPATH standards are not universally held or widely held. But here, based upon the preliminary injunction record at least, the court has made a factual finding that they are. And that we review for clear error. And so I understand that there's all this literature out there, otherwise, and I understand from the amicus briefs that there's maybe some dispute about the motivations behind the WPATH standards, et cetera, et cetera. But none of that was before the district court. And we are limited to the record in this case and what district court found in this case. And so I guess based upon that, I come back to my original question, which is, how do you show clear error?
So, Your Honor, all of the literature I was just describing was admitted at the hearing. That you can find it at docket 54.
And the court weighed it, and it determined that, for example, it determined that Dr. Levine's testimony was not credible, and that the other facts, the other testimony and evidence was, which district courts do all the time. And that type of weighing is, the province really of the district court, which is why we have such a deferential standard.
Well, I think, Your Honor...
And so aren't you just asking us to reweigh the evidence and give it different weight than what the district court did?
No, Your Honor. And I think that's because the standard here is not which expert has the best view of how this particular plaintiff should be treated. The standard is there genuine debate? And the district court did not address any of the medical literature showing there is a debate. It just said, I'm more persuaded by the plaintiff's expert. And now turning to the individual plaintiff, I think we have the same problem. We have two physicians who are psychiatrists who examined the plaintiff, Dr. Beers and Dr. Fragela, who said, I don't think this plaintiff has distress is related to gender dysphoria, and we do not recommend surgery. And now, of course, the plaintiff has an opposing expert, but because this comes back to being a subjective standard, I don't see how the district court could find that the department actually knew and disregarded a risk when two specialists who examined the plaintiff said, we don't think that the plaintiff is a candidate for surgery. That seems to be the precise sort of exercise of difference of a professional opinion.
I guess, but the district court discounted, again, thought that second expert was not credible because she did not have the requisite experience in this area, which is, again, something the district courts seem to do all the time. If I could just ask, going back to my kind of my inartful cancer discussion, because Lord knows I'm not a medical professional. Let's say that there's an option between radiation and chemotherapy, as you said, in that fact scenario. And let's say that it's undisputed, again, hypothetically, that for this particular person, individual A, that radiation won't work, but chemotherapy will, okay? Or that chemotherapy could possibly work, but radiation certainly won't. Given that fact situation, and the legislatures in that fact situation's complete ban on chemotherapy, under that scenario, would those facts create a violation of the Eighth Amendment?
I think we would have a harder case under precedents like Roe, but I think there could be factual nuances that actually change the outcome. For example, this court has said For example, cost can be a relevant consideration in formulating policies. And I think likewise it would depend on, what is the level of certainty regarding sort of, one of the two options.
Okay. Any other questions? I will give you some more time on rebuttal.
Okay,
Thank you. Mr. Falk.
Good morning, and may it please the court. This case is Roe. This case is Fields. This is a blanket ban on the provision of medically necessary care to treat a serious condition, gender dysphoria.
Mr. Falk, let's say that say that there was a honest disagreement among professionals whether or not your client needed the surgery.
Yes.
Okay. And it's not even the predominant view, but let's say that, that there was a competent expert or series of experts that pointed out some good faith reasons why perhaps surgery is not necessary for your client, right? And IDOC, based upon that, says, surgeries, we're not going to give you the surgery here.
Yes.
Under that fact scenario, would you still argue that that is a violation of the Eighth Amendment?
Well, obviously, if you have a podiatrist examining her and someone who's experienced with gender dysphoria, that I would say yes. But so all things being equal, that no, that's what the Eighth Amendment law tells us. But that's not the case here. Dr. Fargella admitted that he had no experience examining persons for gender dysphoria, and the court therefore did not credit his testimony. Dr. Beers, not only did the court question whether she had any experience, but she herself said she had no experience and she was not comfortable doing the examination. The facts in this case, the district court established that doing evaluations is a subspecialty that requires you to not be the podiatrist in my example. So that is not the case. And what this is really, as the court has noted, this is a clear error case. At no point does the DOC claim that the findings the district court made that gender-affirming surgery is safe, effective, and medically necessary. At no point do they say that's clear error. And they'd have a hard time doing that because prior to this law, the DOC allowed and approved of prisoners to obtain gender-affirming surgery under a standard that specifically required it to be medically necessary. And of course, Ms. Corleone was examined by Dr. Randy Etner, who's treated more than 3,000 persons with gender dysphoria and gender other issues. And she concluded that she had severe gender dysphoria. And without treatment, without the necessary treatment of surgery, would suffer severe harm, perhaps going into suicide. And I'd like to also point out, this is not a WPATH case. Not only was there no evidence to the district court concerning any controversy concerning WPATH, because Dr. Levine was mostly Delaware, but the district court's findings are that this surgery is medically necessary. Dr. Levine, not a fan of the current WPATH, has approved prisoners for surgery, obviously assuming that it was medically necessary for them. So the question is, given the record in this case, and given that the evidence in the record establishes that this is medically necessary surgery that is absolutely precluded by Indiana law, the only question is that an Eighth Amendment violation. And as the court has noted, that's Roe. That's Fields. Refusing to provide effective treatment for a serious medical condition serves no valid penological purpose and amounts to torture. The Eighth Amendment requires, and we talked about, requires individual medical determinations, but the law doesn't allow for that. And we would be in a completely different place if this was a situation of an expert A, expert B, and what have you. That's not this. This is a record created through evidence heard before the district court. The district court saw Ms. Corleone. The district court saw Dr. Etner, albeit on video, the same with Dr. Levine. Ms. Corleone was in person, and made factual conclusions. We don't hear the state saying they're clearly erroneous. We hear the state saying, well, there's medical journals that say X, Y, and Z. Well, those are all journals that Dr. Levine was relying on, and his testimony was struck under Delaware. This is a clear error case, and there is no clear error. What we have here is a complete ban on what is established to be medically necessary surgery, and denying that, this court has held, and other courts have held, and the Eighth Amendment holds, violates the Eighth Amendment.
Do you agree that Indiana could ban categorically some medical procedures?
Indiana could ban a medical procedure if there was another medical procedure that was equally efficacious. Indiana could not say tomorrow, you know, chemotherapy has gotten really expensive, so we're not going to do that anymore. That's Roe. That's Fields, right? What this court said in Fields was the legislature, I'm quoting, cannot outlaw the only effective treatment of a serious condition like gender dysphoria. Now that was said in the context, of course, of the medications, of the hormones. But if in fact Indiana bans the only effective treatment for condition of your choice, and that's a serious medical condition, that is an Eighth Amendment violation.
What is the level, to what degree must the level of debate rise in your mind for the legislature to be able to say, you know what, there's genuine disagreement amongst experts, and so as a policy decision, we're going to ban this particular procedure?
Well, excuse me.
It seems like the legislature does have the ability to do that under certain circumstances, and I'm wondering, under your rule, when would that be?
Well, again, I'd have to say that's not this case. I mean, there's no evidence of that debate. There's a lot of noise outside the record in this case, but there's nothing in the record to contradict the judge's conclusions that the PAF standards are credible and
No,
persuasive.
I understand your position. That's not the record in this case, but I'm just, you know, we're one of our jobs is to try to articulate a rule,
Sure.
right, of that district courts can follow, and I'm just wondering whether, in your mind, how much good faith debate is necessary for the legislature to be able to act on as a policy matter.
I think whatever debate takes place has to take place against the backdrop of, is there another way to treat this serious medical condition? If you look at the Supreme Court's partial birth abortion case, there was a lot of debate about that in the record, about whether it was advantageous or not, or whether it was a good procedure or not. But if you review the case, what the Supreme Court ends up saying is, yeah, the legislature could rely on this, and there are other ways of getting abortions, that you don't need this procedure. So I don't think the Indiana legislature could ever decide that, yes, we acknowledge that X is a serious medical need, but we're going to disallow any way of getting that treatment. So I think that's the answer.
Can we turn to the nature of the order
Yes.
that the district court issued? So the order requires IDOC to provide your client with surgery at the earliest opportunity, and I think that language may come from the Ninth Circuit case or the Consulate case, the Ninth Circuit case, perhaps Edmo, one of
Yes,
those
I'm
Ninth
sorry.
Circuit cases.
Yes, I apologize.
But that was a permanent injunction. I mean, it seemed like that was kind of after all the merits have been decided. Here we're at the preliminary stage, and what the state argues is that, look, you know, if the plaintiff has provided this surgery as part of this preliminary injunction order, that's basically tantamount to a permanent injunction,
Yes.
right? And the district court hasn't made the necessary findings to do that. And so what is your response to that?
Well, I mean, this obviously is an affirmative preliminary injunction in the sense that you noted, but the district judge made that decision after weighing the preliminary injunction standards and finding that, given the equitable standards as well as the probability of success on the merits, that is what is warranted, that she should receive that the DOC should take all reasonable actions to secure surgery at the earliest opportunity. And you see that. I mean, you saw in.
But but the basic, stepping back, kind of 40,000 foot view, the basic nature of a preliminary injunction is particularly, before the merits are decided, is to kind of provide kind of a status quo, right? At least with regard to the final decision. And here, the nature of the order seems to affirmatively give the plaintiff the relief that is being sought in this case. And so I guess I have a hard time seeing how that final relief, that is the surgery itself, is preliminary in any way.
Well, again, there are preliminary injunctions outside of this case where courts award what is in essence what is the relief requested for final injunctive relief.
But in those instances, though, the court also considers whether that relief can be undone, right? In the case that the other side ends up winning the merits of the case. Mm-hmm. Here, I think everyone is agreeing that if your client has provided the surgery, that there's going to be no effort to kind of undo it.
I think that is correct, yes, Your Honor. I mean, all I can say, Your Honor, is that is the calculus that the court reached using the standards for preliminary injunction. That's what the Southern District of Illinois did in the Iglesias case, granting preliminary injunctive relief. And of course, in Monroe v. Meeks, the preliminary injunction was entered to supply prisoners with necessary surgery. When a court is faced with a request for preliminary injunction, the court says, look at the standards. That's what the district court did, and the district court found that this is exactly what was required under Rule 65, given the extreme harm that Ms. Corleone was facing and continues to face today.
What is the current status of things with Ms. Corleone?
Ms. Corleone has not received surgery, and I believe this has been reported to the district court, so I'm not speaking outside the entire record. At the time of the preliminary injunction, there was one doctor in Indiana performing this surgery. He has since indicated he would not perform surgery for prisoners in the Department of Correction. He's not associated with the DOC or with their contractor. The DOC has contacted and is still contacting other states to determine if Ms. Corleone can be transferred under the Interstate Compact to get the medical care. Not every state has responded, so the DOC is periodically submitting periodic reports to the court as to that progress.
So at this point, at least, there's no particular time frame, at least.
That is correct.
That has been said.
That is correct.
Counsel, a practical question.
Of course.
I read that Ms. Corleone is scheduled to be released. Is this,
yes.
How definite or indefinite is the December 2025 release date?
As we noted in our briefing, when this case was decided, her out date was December of 2027. She has picked up enough good time, as it were, so that her earliest possible release date is December 29th. It's a possible release date, which that date can change if she loses that time. So we're not in a situation today where things are moot, but it's certainly possible that she will be released December of this year. My understanding is she has no opportunity to advance that date any further, only to lose time.
Can I ask a question on the 14th Amendment claim? So after the court's first ruling, we had a ruling in case C. I understand the record to be that the court kind of reversed itself on the 14th Amendment.
Yes.
Is there anything that your 14th Amendment claim accomplishes, assuming that we were to affirm on 8th Amendment grounds? Is there any reason to address the 14th Amendment?
Well, I think the Supreme Court in the Scrimeti case, which is probably going to be handed down in the next 6 weeks, is going to tell us. Obviously, if the Supreme Court goes the way of this court in KC, finding that there's not a higher level equal protection analysis to be applied, then there's nothing to be gained. If the court in Scrimeti says that this is entitled to elevated scrutiny, I think that's another grounds to get to the same place that we're at now.
I understand that. That's kind of why I'm asking. Is there any, if we were to affirm on Eighth Amendment grounds, is there any additional relief? Is there any reason that we would have to reach the 14th Amendment?
I do not believe so. Thank you.
Thank you.
I apologize for being evasive.
No,
Did you cross appeal the district court's 14th Amendment
did not.
determination? Okay.
Thank you very much.
Thank you. Mr. Berta, I'll give you 3 minutes.
Thank you, Your Honor. Let me start by picking up on some of the procedural questions that were asked. So, Judge Lee, you mentioned the problem of the district court's injunction providing effectively what amounts to final relief. And I think that's particularly salient here for 2 reasons. One is this complaint was framed as alleging the problem was there was no individualized evaluation. And so if that is really the constitutional problem we're talking about, then just saying evaluate the prisoner through in the ordinary courts would fully remedy that problem. And it also doesn't create the same sort of potential problem of mooting an appeal just before it can be heard by this court. And I think the second reason why this is particularly salient is that there is a real question here about whether the prisoner could have succeeded on an Eighth Amendment claim if the statute had never been passed. And I think we see that through the evaluations, not only of Dr. Frugela, but particularly of Dr. Beers, who prepared a 12-page single-space report saying, I've looked at, interviewed the plaintiff, I've examined the medical record, and I don't think that surgery is the answer for the distress the plaintiff is experiencing. Now, if this were an ordinary Eighth Amendment case, perhaps you would have experts that are debating that, but I think it would be very hard to say there's deliberate indifference based on that careful evaluation, especially when the plaintiff is being provided other treatment to try to eliminate the distress. That includes the plaintiff was seen over 50 times in the last couple of, I think since 2019. The plaintiff is reporting that I'm more okay with my identity now. You have Dr. Frugela, who thought, based on his evaluation, that the plaintiff had largely come to terms with his identity. And I think that would raise the very type of factual question that would, about a difference of a medical opinion, that would preclude a prisoner from succeeding on an Eighth Amendment claim. And, in cases where we're talking about an ankle injury or something more mundane. As to the...
What is the... can you give me any more information with regard to the status of IDOC's efforts to try to schedule the surgery or have her evaluated for surgery?
So the Department of Corrections has contacted surgeons throughout Indiana. No surgeon is willing to perform the surgery, which I think is, sort of as an aside, somewhat salient as to, whether this is in fact necessary. But in the department has also contacted other states. Now, to be clear, we don't think that the prisoner can be transferred to another state because there's a specific section of the PLRA that governs transfer orders and requires transfer orders to be made by a 3-judge court. But the department, as the district court has noted, has been making reasonable efforts to try to comply with the injunction.
Is there any sort of time frame that you could give us with regard to when you think the procedure would be able to be scheduled?
I can't say, Your Honor. I will note that there has been testimony in this case that generally, not speaking the case of this particular prisoner, but generally this can be a very long process. I think Dr. Entner said there's usually about a 2-year wait list in her office. Another surgeon who previously performed surgeries in Indiana also had about a 2-year wait list. So this, even if you found a surgeon willing to perform it, it could be quite some time before any surgery actually happens.
Okay. Thank you. The case will be taken under advisement. Thank you to counsel. The next case is United States versus Carpenter 242914. Ms. Garst, whenever you're ready.
Thank you, Your Honor. May it please the court, my name is Hannah Garst. I'm here today on behalf of defendant appellant Joseph Carpenter. This case presents the question of whether the government proved beyond a reasonable doubt that Mr. Carpenter attempted to sexually exploit a child. Now here it's our contention that the government failed to prove that Mr. Carpenter took a substantial step or demonstrated specific intent to use, persuade, induce, entice, or coerce a minor to engage in sexually explicit activity for the purpose of creating a visual depiction. Now at trial, the district court granted our Rule 29 motion at the end of the government's case, and this was related to a child enticement charge. The court found that the government failed to prove that Mr. Carpenter persuaded, induced, enticed, or coerced a minor to engage in sexually explicit conduct. Now that leaves several elements of the sexual exploitation charge, including the use of a minor and also the purpose. The purpose of sexual exploitation must be production, and that is part of the reason why sexual exploitation carries the increased mandatory minimum of 15 years versus a child enticement case, which is 10 years. So there is the additional elements there. Again, sexual exploitation requires the production. That's the ultimate purpose. So the question before the court is, did Mr. Carpenter attempt to use Haley, the little girl, to engage in sexually explicit conduct to produce the visual depiction? Now, the government put forward evidence in terms of chats. That was the only evidence that was provided to the court. And in these chats, it's our contention that attempt is not proven. First, Agent Garrity is the first to suggest taking pictures of Haley. Agent Garrity is the first to talk about taking pictures of Haley while she's sleeping. Agent Garrity suggests meeting up. Mr. Carpenter never takes him up on that. Agent Garrity states that he's going to take pictures of Haley, and then in turn, Mr. Carpenter asks for a copy of those pictures. Mr. Carpenter never agrees to meet, he never directs, he never asks to convey any messages to the minor, he never specifically asks the minor to do anything in particular.
But he does make suggestions on how to drug the minor, and he said he doesn't direct, but he did talk about specific images he would like. Is that accurate?
When he spoke about the Benadryl, it was in direct response to Agent Garrity saying he was going to take pictures. When Mr. Carpenter said you could give her Benadryl, Mr. Carpenter at that point had not asked for any pictures himself. Now, later on, Agent Garrity continued to request from Mr. Carpenter, what is it that you want? What is it that you want? And in that case, Mr. Carpenter did respond that he wanted a picture of the child's genitalia. But again, it was always in response to Agent Garrity. At one point, Agent Garrity said, what is it that you want? Mr. Carpenter responded, anything you'll give me. Agent Garrity comes back, says, no, I need to know what is it that you want. He again says, anything that you're doing. I'm not picky. And the third try was when he stated, I'd like a picture of her genitalia. But again, he was convicted of attempted receipt of child pornography. And there's no question here that he was trying to obtain the pictures that Agent Garrity himself was directing. Agent Garrity was saying that he was going to take the pictures. He was going to do these things to the daughter. And Mr. Carpenter was responding, I'd like a copy of those pictures. I want pictures. And that is why the jury found him guilty of the attempted receipt.
Does it matter who mentions the pictures or taking the photos first? So in other words, if the intermediary, right, says, you know what, I'm thinking about taking some pictures, you know, do you want any, right? Or do you want me to take pictures? And the defendant answers, yes, I want you to take pictures. Okay. In your mind, is that enough for the 2251A count?
We would suggest that, you know, as in Harlow Road, the court said that you can have direct no direct communication is required. However, the nature of the communication is important. And I think that the nature of the communication here is telling. Because if you look at the cases, the other 2251 cases, it's not that someone's saying, I'm going to take pictures and I want them. It's saying what type of pictures that you want. In Harlow Road, he drafted a script. He sent the script. He made arrangements for the Skype meeting. He changed his work schedule to be present for that Skype meeting where he was intending to direct. So the nature of the communication, Judge Lee, I think is really important. And to just say, I want pictures or I want a copy of pictures, there's no directing. There's nothing active there. There's nothing that's specifically showing how, even through the use of an intermediary, how is the defendant causing this minor to engage in sexually acts?
What if the defendant says, you know what, I want you to take pictures of the child's genitalia. Can you do that? And the intermediary says, yes, I can. Is that enough?
I think that if it's the defendant's idea in saying, I want you to take pictures of X, I want it to look like this, I want 10 pictures, then according to the cases, that would be enough. But here, our position is that the difference is that Mr. Carpenter is continually responding. And in general stating, I will take a picture of this. But in the chats, he's continually coming back and saying, do you have pictures for me? And it is Agent Garrity who's saying, I'm going to actively take these pictures. I'm going to do this. I'm going to do it while she's sleeping.
Ms. Garst, though, I'm looking at Agent Garrity's testimony, and the photo discussion started with Mr. Carpenter. Right, Mr. Carpenter, I'm looking at page 51 of Agent Garrity's testimony. I think we're losing some context here, which is he was talking about nudes of his 3 stepdaughters, and that's how photos came up. So he was sort of, one could say maybe mentoring, this is what I did. And that's how the interaction started, right? I mean, what do you do with that whole line of texts? That preceded the agents ask for the photos. Or the agents asked for, what do you want? It didn't come out of thin air, right?
This did not come out of thin air.
Yeah.
There were chats that were going on, obscene chats, discussing past alleged abuse that Mr. Carpenter had done with his stepdaughters. That's how it started. But the point that we're trying to make is that Agent Garrity was the first one to bring the 8-year-old Haley into the picture. It was Agent Garrity who then says, I'm going to take pictures of Haley and I'm going to do it while she sleeps. And on that same day, Mr. Carpenter never asked for pictures. It was later in the chats that the whole thing is, I'd like the pictures that you take. I'd like a copy of those. That's when it came up. So I'm not trying to misrepresent in any way that there were these chats that going on, but in order for it to be a production charge, a 2251A charge, the fact that they're producing, that a defendant is asking to produce or attempting to produce images of that child matters versus some of the other ways that the government can charge these cases.
If I might get your view on something with regard to these cases involving intermediaries, right? You see more and more of them. And in terms of attempt charges, does it matter whether or not the intermediary agrees to do it? So in other words, if you have an attempted exploitation or attempted use, and let's say the defendant reaches out to an intermediary and says, can you, I'd like some pictures. Can you take pictures? And the intermediary says, no, I'm not going to do that. Is that still a attempt for violating 2251A? I'm just trying to understand kind of what, if any, relationship there needs to be between, or agreement or assent, or between the defendant and an intermediary.
I believe that if you just asked and the intermediary said no without giving more specifics, that would be an expansion of 2251A and the intent of that. I mean, if you look at even at the child enticement cases, where use of intermediary has been more written about, that the defendant actually has to do something to affect the mind of the minor. So the defendant, whether or not the intermediary says they're going to follow through or not, there has to be that step, and that's what this court has said in Baird. And for a sexual exploitation charge, you would expect, given that it carries a 15-year mandatory minimum, that there should be something to cause the actual production, to show that, but for this just being an intermediary, that this would have actually happened. So I think in terms of what the intermediary says, that would be an expansion. I think it's more important to look at what the defendant is doing. What are they saying? How are they planning? How are they directing the actual production here, especially in terms of how this was charged? And what we're really talking about is the use of a minor. And use can be expansive, but the courts have kind of said, we can't just leave using a minor to be completely expansive. There was the case of Howard where there wasn't even a minor that was in the picture. So, and the court has said, no, that's not enough. The minor has to be in some way connected to this. So it would be our perspective that if there's an intermediary, that it's really important to look at the actions of the defendant and how the defendant has demonstrated that their intent to actually produce, if all goes as expected.
So let's say the defendant, and this is just a thought exercise, let's say the defendant gave the intermediary a script, okay, and said, these are the photos I want, these are types of poses, and the intermediary says, you know what, no, that's too far, I'm not going to do that. Would that action of sending the script to the intermediary, in your view, be sufficient to convict the defendant on an attempted exploitation charge?
Yes, Your Honor, because it is, again, focused on the defendant and the defendant's intent, the defendant saying, this is what I want to carry out, but for the intermediary not being there or being an undercover, that would have been successful. So under that test, yes. If I may save the rest of my time. Thank you, Your Honors.
Thank you. Good morning, Mr. Simpson.
Good morning, Your Honors. May it please the Court, I'm Scott Simpson on behalf of the United States. This Court said in the Hartle Road decision, and I'm glad we have that decision here to help us in this case, requests to have a minor take and send pictures matching certain descriptions are sufficient to support specific intent to produce child pornography under Section 2251. And Hartle Road, of course, has been referred to, also said that direct communication with the minor is not necessary. And all of that is exactly what happened here. Now, true, there are some facts in Hartle Road that supported the finding there, the verdict there, that aren't in this case, but there are also facts in this case that were not in Hartle Road that further support the verdict here. And this case easily satisfies all those requirements. If I could just summarize the evidence here. Some of this has already been referred to. In his conversation with the agent, it was Carpenter who first brought up the subject. I believe, Judge Lee, I believe you referred to this earlier. It was in that conversation, it was Carpenter who first brought up the whole subject of producing sexually explicit images of minors, talking about his granddaughters. I believe that was Judge Maldonado, actually, I think. When the agent then said he wanted to create sexually explicit images of his daughter while she was sleeping, who was it who first brought up medication? That was, again, Mr. Carpenter, who raised the subject of medication. He suggested either Benadryl or melatonin, and then later he recommended Benadryl. And it was Carpenter, again, who suggested telling the minor that the melatonin gummies were candy. He suggested a specific communication to the minor, and he actually advised a specific dosage of a specific product. So the upshot of all of this, what we're seeing here is that Mr. Carpenter was advising the agent, the supposed father, on how best to put his daughter in the best frame of mind, in the best mental state to facilitate producing child pornography. That is, to make her unable to resist or object. And then Mr. Carpenter repeatedly asked for images of a specific part of the child's anatomy, as has been referred to, the genitalia. Now, I must disagree on one part of what counsel for the defense said. It's actually later in the conversation. This conversation went on for quite a while. Later in the conversation, yes, the agent asked a number of different times, "What do you want? Is there anything specific?" But very early in the conversation, and this is on page 15 of Government Exhibit 5 from the trial, the very first time, on page 15, the very first time when the agent says, "Anything special you're looking for, you want me to take?" And right after that, in response to that, I won't use the term that Mr. Carpenter used, he said he wanted a picture of a specific part of the child's anatomy. Now, true, later on, the agent said again, "Anything specific you want," but right there, the very first time when the agent said, "Anything specific you want," Mr. Carpenter jumped in and said, "Yes, I want that part of her anatomy." And later on, he also said he wanted action shots, in addition to saying yes again and again. "Yes, I want pictures of that specific part of her anatomy." Mr. Carpenter suggested that the agents could progress from touching to kissing. At one point, the agent said, "I might make it a game," and Mr. Carpenter specifically suggested the parameters of that game. And then he also even guided the father, the supposed father, the agent, in what not to include in the pictures. That is, be sure you don't include, and again, this is totally volunteered out of the blue from Mr. Carpenter without any prompting from the agent. Make sure you don't include any pictures of your face or the daughter's face to protect yourselves. And Mr. Carpenter, who was very persistent, asking for sexually explicit images at least 6 different times, and saying at least 6 other times, additional times, that he couldn't wait to see those pictures. And of course, all of this was in the concept, in the midst of telling the agent very graphically about his own sexual activities with his stepdaughters, including creating sexually explicit images. And then it was Mr. Carpenter, and this is probably the main part of his overt act toward the attempt. It was Mr. Carpenter who suggested using Dropbox to transmit the images and sending his email address for that purpose. I can't imagine how all of this could not constitute attempting to use a minor to engage in sexually explicit conduct to produce a visual depiction of that.
Mr. Simpson, if I could ask you that fact scenario where a defendant reaches out to an intermediary and says, can you take nude pictures of your minor child? And the intermediary says no. Is that request sufficient in your mind for conviction under attempted violation of 2251A?
I think, Your Honor, it would depend on the circumstances, of course. And I think in looking at those circumstances, the court would focus on the verb use or employ in the statute. let's pretend like there had been no indication during the conversation even that the recipient of that request had minor children, had minors available to him or her. Probably that would not be enough for a 2251 conviction. But yes, if I think the answer would be yes, if again, based on the circumstances, if they had discussed the recipient's minor children, yes, I think that probably would be enough. I think that would satisfy the specific intent. There would have to be some overt act for the attempt. Perhaps sending the requester's email address would be enough.
You don't
for
think that alone would be you wouldn't rely upon the request alone to be a overt act or substantial step?
That may well satisfy it, Your Honor, yes. We would certainly want more than that, ideally, but the request, depending on the circumstances of the conversation, that could well be enough to support the 2251.
It seems like, and the reason I ask is because it seems like a very broad application of the word use, right? I mean, it would encompass, I think, a lot of cases. And I'm wondering if there's any kind of limiting principle in your mind about, use of that word.
Well, Your Honor, if it's broad, it certainly is broader than 2422, the enticement. And for whatever reason, it was Congress who put in those words use and employ in 2251. They're not found in the enticement statute. So to the extent it's broader, then it is Congress that made it broader. So again, it would depend on the circumstances, but Congress made it broad. Use and employ, yes, those are broad words. If I could address the other claims, I don't know if the court is interested in those. We have two other claims: a constructive amendment claim, and the actual challenge to the jury instruction. We have there's a claim preservation issue on the constructive amendment claim, but now having mentioned that, I should say the outcome would be the same, we believe, no matter what the standard of review would be. But the defense actually never made an objection to the jury instruction that they say constituted a constructive amendment. The closest they got was objecting to an earlier proposed jury instruction on the exploitation count, and they said that doesn't mirror the indictment. That was the argument, and that, of course, I believe would constitute a constructive amendment objection, that it doesn't mirror the indictment. But then that instruction that they made that objection to was never actually given. The government withdrew it, and the court actually expressed reservations about it. But then the government proposed an instruction that basically stated the core of this court's decision in Hartle Road, the core of the holding in Hartle Road. The earlier instruction talked about causing another person to use a minor to engage in sexual explicit conduct. That one was withdrawn. But then the whole point of the instruction that was actually used was that the communication can happen through an intermediary at the kind of the core of the Hartle Road holding. The defense did object to that. That intermediary instruction, but they objected that it was a pattern. It was not a pattern instruction, and they objected that the government, in proposing it, was citing a couple of decisions that were actually on 2422 instead of on 2251. So they did not actually make a mirroring the indictment objection to that instruction that was actually given. Besides, under any standard of review, there could be no successful constructive amendment claim on that instruction. The indictment itself simply tracked the statutory language, and this court has said in Hartle Road that the communication can happen through a minor. And that's just what the instruction said, and so it was basically, saying This is the statute, and the challenged instruction here was simply referring to what Hartle Road said was that statute meant.
And you just mentioned standard of review, and I don't want to put words in your mouth, but said under any standard of review. Your Rule 29 case law does seem somewhat distinguishable. Do you agree that we don't need to reach that issue?
So, Your Honor, that's of course a different claim preservation issue. What I've been talking about is the claim preservation issue on the constructive amendment. This court has said that the defense has to either make a Rule 29 objection at the close of all the evidence, or file a Rule 29 motion after trial. And actually, the defense didn't do either of those here.
But all your case law is distinguishable because here it was the functional close. There was no additional evidence.
It was
I'm
the
not sure that's
functional close.
an issue we need to reach.
And I deliberately did not talk about that at the beginning because we recognize that, and again, under any standard of review, the claims are without merit. So finally, Your Honors, just 1 minute on the final claim, the actual challenge to the jury instruction, also obviously without merit. That instruction simply stated what the holding was in Hartle Road, so it obviously stated the law correctly. So, Your Honors, unless there are any further questions, we would ask the court to affirm.
Thank you, Mr. Simpson. Thank you. Ms. Garst, I'll give you 3 minutes.
Thank you, Judge. Just on one point, you were talking about the expansiveness of the word uses. And going back to Howard, this court noted that uses cannot just be expansive. Uses has to be, the word uses in the statute must be construed in context with the other verbs that surround it. So to insinuate that Congress just expansively looked at 2251 and tried to make it larger than 2422, the child enticement, it would be our contention that that really doesn't encompass a reading of uses that doesn't make every case into a sexual exploitation case. The way these cases come up is often when you have an undercover agent soliciting, trying to find people that are looking for children. So under the government's definition, what they could do is say, hey, I have a child. Do you want pictures? The defendant then says yes. Then the undercover agent says, what do you want? Then the defendant says one thing. Under the government's definition, that's sexual exploitation. That's almost every case that comes before this court. And it would be our contention that that would be over broad for the intent of every person seeking child pornography is not a producer. They may be trying to obtain it, but that does not turn them into a producer. And that, for that reason, is why we're saying there must be more. There must be more from the defendant to demonstrate both their intent and the substantial step. Unless there are additional questions, thank you, Your Honor.
Thank you.
Thank you.
The case will be taken under advisement. At this point, the court will take a 5-minute break. We'll now proceed to the fourth case today. That is appeal number 24-2286, Pam versus City of Evansville. Mr. Miller, whenever you're ready.
Good morning, Your Honors. My name is Mark Miller. I'm an attorney for the Special Administrators of the estate of Rico Pam. Mr. Pam died on November 8th of 2020. He was killed by 2 police officers of the Evansville, Indiana Police Department, and the court granted summary judgment in their favor, and we are here on our appeal of that determination. In my comments, I'd like to focus on 2 issues that I think are the key to our appeal and also the defendant's or the appellee's position. First of all, this court has said on more than one occasion that summary judgment is often not appropriate in cases involving 1983 liability due to the fact that they're very typically fact-sensitive cases. There has been also comments to the effect that if the victim is dead, then summary judgment should be rarely granted. It's not always that phrase I'm not trying to quote, but that is the intent, I believe, of this court's prior decisions. What's missing is, what do we do? How do we treat this fact, which is undisputed? Mr. Pam is deceased, and he was killed on November 8th, 2020 by officers McQuay and Offerman. The significance of this is that there's no one who was there at the scene who can contradict the story, the version of what happened that the officers submit. If there is no one to tell the opposite side of the story, then the death has silenced the victim and made it impossible for the victim to testify. We discussed this in our briefing about whether, I think we used the word inference, should be drawn in favor of the state, that the summary judgment should be denied. I didn't say, but I'd like to add to that, unless it's the overwhelming evidence or rebutted by other evidence. So if there were, for example, to use an example, we have body camera footage here that from both officers that I think even the appellees argue is inconclusive and should not be considered to contradict the testimony of the officers, but they also argue that the officers' testimony is corroborated by the video. So, but in this hypothetical situation, if you had a case where that were not the case, you had a well-lit, well-defined view of what happened, then that would overcome this inference or rebuttable presumption. We don't have that here, and I think that the fact that we don't have it is undisputed because the detective who investigated the use of force and the potential for a criminal activity in this case found that the evidence was not conclusive that Mr. Pam pointed a gun at the officers. He said he could not see that occurring. That evidence was disregarded by the trial court. That evidence was given no weight. The death itself was disregarded by the trial court and given no weight. That, in our view, it should make this court would be justified to reverse and remand for reconsideration or trial.
How would
Yes.
that officer, I think it's Ardball, how would his testimony come in as evidence if this were to go to trial? Because he was not, he's not talking about personal knowledge, right? And with regard to what the video shows, he's not offering anything that a jury or a trier of fact or the court wouldn't otherwise see. And so I guess I have a hard time understanding how his testimony or the testimony of Ms. Boyd would come in if this case were to go to trial.
I think the evidence that would go in, Your Honor, is the body cam footage, which is inconclusive as to whether or not Mr. Pam was pointing a gun at the officers. That comes in. Whether we can get the testimony of the investigating officer and his conclusions as part of that process, which is mandated by law and local practice, I agree, we have a hill to climb on that. I don't disagree with you. So the absence of a rule for these circumstances, the situation where the victim is killed, creates a couple of problems that we don't think were addressed by the court and that this court should address. And the first is that Rule 56 is intended to be granted only when there are no genuine material disputes of fact. The burden, clearly under the rule in the cases, is on the moving party. In the 1983 context, and particularly in the case of a victim who's been killed, this has turned the burden around. And the burden on summary judgment has become the burden of the victim to prove that the acts were unreasonable under Graham and also not subject to qualified immunity. That, I don't believe, is a correct application of the concept of Rule 56 and the Rule 56 terms itself. But more importantly, it leaves the victims of police force in a situation where they can never win. And absent an extraordinary set of facts with clear body cam footage showing that something has happened, they cannot win. Or an eyewitness or someone who testifies contrary to the evidence of the police officers. So in other words, the effect of all of this is that the police officer's version of what happened becomes undisputable, which creates, and I've argued this recently in another case, but I believe it to be the case, it creates an incentive, whether it's followed or not, whether it's intended to be or not, to kill the person, so there is no victim.
Mr. Miller, can you identify some authority, another court that has supported that view?
Other than the cases, decisions of this court and the Ninth Circuit, I think, we cited in our brief, no, Your Honor. I've been unable to find any guidance on how the court should look at summary judgment in the context of where the victim of the excessive force has been killed. If there are no more questions, I'll reserve.
Actually, counsel, I have a question.
Yes.
I watched the videos, including the R-ball video, and at one point during the video, the officer says, this came out of his right pocket, that was out of his right pocket. I wanted to stay there, referring to the firearm. Is there anything else in the record about those statements from
Yes.
Officer Arbrough? Was he deposed? Did you make an argument about them?
We made an argument about the photograph of the things that Officer
I know
Arbrough-
the photograph, but about the body cam comments by Mr. Arbrough.
No, we did not. Thank you.
Thank you. Mr. Coruscant?
Good morning, Your Honor. Matt Caressel. May it please the court, my name is Matt Caressel, and it's my pleasure to stand before the court today on behalf of Officer Corey Offerman and Sergeant John McQuay. I'd like to begin my time by addressing several of the arguments that were raised by appellants. Yes, the Seventh Circuit precedent is clear that these can be fact-sensitive cases. There is precedent to suggest that a deceased victim can make these difficult, but to that I'd say we have numerous decisions of this court affirming grants of summary judgment in excessive force cases and specifically lethal force cases. So to affirm the district court's order here would be simply to follow the established precedent of this court. And I believe I heard a concession by appellants during their time that there is not a contradictory version of events, any version of events to contradict what the officers have said. And under Rule 56, under Anderson versus Liberty Lobby, that means that the order must be affirmed. A lot is discussed by appellants with, I believe it's actually Officer Campbell's testimony. He was the detective who was deposed, and when asked, stated that he could not see a gun at the exact moment or the second before the shots were fired. And I believe Your Honor also made a reference to the testimony of Miss Boyd. And I think a very good point was made is that testimony by both of those individuals is not admissible evidence, it's commentary on evidence. And that does not defeat a summary judgment motion. Starting with Officer Campbell's testimony, appellants seem to suggest that the body cam video must perfectly corroborate the other undisputed material evidence in order for summary judgment to be proper. That is not the case. There is no contradictory evidence to the video or the officer's testimony. The video does not show empty hands. The video does not show surrender. It does not show something else in Mr. Pam's hand. So the fact that the video does not perfectly corroborate isn't enough for reversal of the district court's order. In fact, summary judgment would be appropriate if there were no body cam video at all. And then secondly, again, the testimony of Ms. Boyd as to what she believes she heard does not come in. It's not relevant. It's more commentary on other evidence and does not create an issue of material facts.
What if the body cam video can be interpreted either way? In other words, let's take another hypothetical case, right? Let's say, if you show the body cam video to 3 different judges, let's say you get 3 different opinions as to whether or not the body cam shows that the deceased pulled the gun out or not. In that situation, would you say that case should go to the jury, or should the judge on summary judgment take a look at it and use his or her judgment as to whether or not, as to what the video says?
That case would not need to go to the jury unless we're talking about some other body camera footage that shows an inconsistent version of events, or the video is inconsistent with other testimony. Here the video is not inconsistent with the officer's testimony. It's just in that one split second before the shot, the video is too blurry to see exactly what is in Mr. Pam's hand. And so that's why we look at the totality of the circumstances, the totality of the evidence. Both officers testified unequivocally in the immediate moments before they used lethal force that Mr. Pam was raising a firearm up towards them. The body camera does corroborate that Mr. Pam had a gun and attempted to use it against the officers, because we see it as the officers approach, lying on the ground next to his body. So again, I think the fine point to be made and where appellants fall short is they're asking this court to reverse a grant of summary judgment because defendant's body camera footage is not perfect. And that's not the standard under Rule 56. They must come forward with concrete evidence to show that there is a contradictory version of events requiring a trial. I'd like to move on to, there's also some commentary about shifting burden on 1983 cases, specifically excessive force cases. At first, I'd note that when it comes to qualified immunity, the burden has always been on the non-movement or the victim to show that qualified immunity is inappropriate. The district court here correctly found that that burden was not met. Similarly, there is a burden for all non-movements on summary judgment after the movement has met his initial burden. And the district court correctly found that the defendants' appellees did more than meet their burden under summary judgment, and the appellants were unable to come forward with more than speculation, conjecture, red herrings. They weren't able to come up with any more than that. Overcoming summary judgment requires concrete evidence. The appellants were unable to present that. So in summary, this case boils down to, well, let me back up a sec. On page 7 of appellant's reply brief, they concede that if the district court correctly determined that there were no issues of material fact, that the legal analysis is then correct. The officer's actions was justified under Graham, and in any event, shielded by qualified immunity. So in summation, the district court correctly determined that there are no genuine issues with respect to any material fact, and therefore the force used by McQuay and Offerman was justified under Graham. Unless the court has any further questions, I'll concede the rest of my time.
Thank you. Mr. Miller?
Thank you, Your Honor. To Mr. Caresso's answer to your question, I think the hypothetical you gave supports our position in this case, which is if 3 people could come to a different conclusion about what happened in that video than 3 jurors or 6 jurors or 12 jurors, depending on which jurisdiction you're in, could come to a different conclusion about what happened on the body cam and what was shown by the body cam. And that's the kind of the key to our point that we've been trying to make, which is that because the victim is dead, and because of the way that the burden has been shifted, it puts the plaintiffs in a position of they cannot win a case without evidence that most of the time, according to this court's comment, does not exist. The 5th shot, the shot that was made by Sergeant McQuay, was intended to make sure that he was dead. That's the testimony, that's the circumstances. Thank you.
Thank you, Mr. Miller. The case will be taken under advisement. Thank you, counsel.
Thank you.
Our 5th case of the day is appeal number 24-2459, United States versus Schwartz. Mr. Hillis, good morning. Whenever you're ready.
Good morning. May it please the court, my name is Daniel Hillis. I'm with the Federal Public Defender's Office. I represent Mr. Schwartz on this appeal. This appeal is about money. It may not seem like that much money to people, but $10,000 is a lot to my client, especially when we get the numbers correct in this case. And that is the overarching problem. The numbers were not correctly determined in this case. We know this, the government agrees with us on this, that the PSR included incorrect information. every criminal defendant has a due process right to be sentenced on the basis of accurate information. That's the Tucker and Townsend line of cases from the Supreme Court, and it also tracks with this court's decisions in Corona Gonzalez, Welch, etc., Miller. So we know that there's incorrect information that was at play here. The question to the government is, where is it in the record that shows the district court relied on it? And the answer is quite simple. The figure doesn't come out of plain air when the judge decides to impose the fines. He's relying on something. He essentially adopted the PSR, pages 26 through 29, when he used it to make various determinations. And importantly, in our view, there's no rejection of the figure that's incorrect in the PSR by the district court at sentencing to say, I see the number and I know it's incorrect. So,
but the way I'm reading the district court here, tell me if I'm wrong, is the references were to assets and cash flow, not net worth.
The references were to net worth because by using the PSR that incorrectly has the net worth, we're incorporating that, and under Rule 32I3B, I think that's right, that the district court, when confronted with a dispute about a fact, needs to make a resolution on the fact. And by adopting the PSR, the district court would have accepted the PSR's version at the $268,000.
So your argument that is, if the judge accepts the facts, but then moves on,
yes,
and in terms of when the judge is specifically relying on it, talks about assets and cash flow, and doesn't reference net worth, that the prior finding is enough because there's the bad facts in the record.
Right. We describe it in the briefing as a fault line that runs through everything else in the case. And I think that's an apt way to describe what occurs here. So for purposes of assessing earnings, assets, et cetera, under 3572A, you need to have an accurate description. When Congress says to assess these things, it doesn't mean to use inaccurate information. And of course, we have the due process concerns separately. And I don't want to get too far into the 3572B portion of our argument, but again, if we're using the wrong net worth, then we are making the wrong determinations that flow both for the 3572A, whether you have the ability to pay the fine, and then separately 3572B, whether or not the imposition of the fine will impact the ability for victims to collect restitution. If my client doesn't have $268,000, he may have, by my count in the math, about $111,000. Once we take into account the remaining $31,000 that was agreed to at the time of sentencing, that is also not offset in the judge's calculations.
But didn't Mr. Schwartz's counsel raise that in his sentencing memorandum, and the government didn't dispute that? And so you say that there's a disputed fact. It seems to me, at least between the parties, there was no dispute that the PSR had incorrectly identified the net worth. And as Mr. Schwartz pointed out in the sentencing memorandum, and the judge, we know, reviewed the sentencing memorandum. And so I guess given that, wouldn't one suspect that the judge would have used the information that at least the parties agreed to?
No, because there were plenty of instances where the judge is trying to get a handle on the facts during the hearing, despite what the parties have laid out, and the judge doesn't have everything right. Judges are very able, but they do not have perfect recall. And so the way that we know that a fact is correctly determined is for the judge to say so on the record. To say that it was wrong here, but maybe it was right later on when the judge made his other remarks, it doesn't, on the record that I see, disambiguate anything. So if it was uncontested, I think that the government could have taken this out of play by saying, we agree with defense counsel that the net worth is incorrectly stated in the PSR. The judge furthermore could have said, I've read the sentencing memorandum and I recognize that there's a dispute about this, and then I think his obligation kicks in under Rule 32I3B to make a determination. When he doesn't, the case law from this court says a reference, very scant reference to the PSR is enough to show that the judge is then using the PSR. Usually that breaks against the defense because everything that we want to contend that the judge didn't consider, use, and incorporate for his determination, we get brushed aside because we are able to then get the back end of this on the Rule 32I3B determination. Here it works in our favor because the judge, by adopting the PSR and not accepting the defense's position explicitly, means the judge used the wrong figures. So, Judge Lee, I think that there is not a way for us to look at this record and conclude that the judge at the sentencing hearing relied on the correct information. I don't think the judge to this day would have an idea that this was the wrong information to be used, and certainly on this record we can't say otherwise, because the judge didn't make an explicit determination in his adoption of the PSR would support our position that the wrong information was used to impose sentence. So with that, I just want to make one final tilt towards the 3572B portion. We know that if, or for 3572A for that matter, let's start there. If the judge had the correct information and my client's net worth is half of what the judge believed it to be, maybe the fine is half what the judge imposed. The difference of $5,000 is substantial for a client who's 60 years old, comes out with diminished earning expectations, loss of salary, likely no more alimony, and a felony conviction. This means a lot to my client for his ability to pay his bills going forward. And for purposes of 3572B, there's an order of operations at play here. I think that fines get paid before restitution, and if the government is going to take its $10,000 now, my client has less ability to pay the fine to the victims, which is supposed to be the first order of business here under 3572B. So the imposition of the fine very definitely impacts my client's ability to pay restitution to the victims, who should be standing here first in line, not second to the government, who's apparently going to get its $10,000.
Did I misread the record that 150 of the 180 in restitution was already paid to the victims?
That's correct, it was.
Okay, and so he has net worth of $140,000?
I think it's less than that, because we have to subtract out the additional $31,000 that was agreed to at the time of sentencing. That's a liability.
Correct. So that's around $100,000. So he's paying a $10,000 fine on a net worth of $100,000.
Very different than a net worth of $268.
Okay.
That's our position. Unless the court has any questions, I will yield.
Mr. Wagner?
May it please the court, Aaron Wagner representing the United States in this matter. The United States is asking the court to affirm the judgment conviction order of the district court. Here it's the defendant's burden to show the district court relied on incorrect information in the PSR when it decided to impose that $10,000 fine. There's absolutely no evidence in this record to show that. In fact, as Judge Lee pointed out, the evidence shows that the district court was well aware of the typographical error in the PSR because the defendant's own sentencing memo pointed it out. And the district court expressly acknowledged reading that sentencing memo during the sentencing hearing. Therefore, at the sentencing hearing, everybody there knew that the correct net worth of the defendant was $143,000. I knew it, the district court knew it, the defendant knew it, and the probation officer knew it. There was no dispute about that. And the reality is because everybody was aware of that typographical error, no one believed it was necessary to address it at the sentencing hearing. Now on appeal, the defendant wants this court to speculate that the district court relied on the incorrect net worth figure in the PSR, even though it flies in the face of several known facts. First, the PSR correctly listed the defendant's assets. Second, the PSR correctly listed the defendant's liabilities. Third, as I mentioned, the district court expressly acknowledged reading the defendant's sentencing memo that pointed out the error. And fourth, and perhaps
Can you direct me to where in the transcript the judge acknowledges reading the defense sentencing memorandum?
Yes, Your Honor. It is page 31 of the appendix of the defendant's brief. When addressing defense counsel, district court said, quote, "I have spent some time with your memorandum." And in the following page, defense counsel, when addressing the district court, said, "Judge, we know that you have reviewed carefully our sentencing memorandum." So it was expressly acknowledged that that had been read by the district court. Fourth and finally, what I wanted to point out is that the district court never referenced that incorrect net worth figure when imposing the $10,000 fine. So the judge talked about the significant assets, which were correctly listed in the PSR. The judge talked about the limited liabilities, which were also correctly listed in the PSR. And the judge talked about the positive monthly cash flow, which was correct. The defendant had a positive monthly cash flow, and the district court knew that the defendant was going to be allowed to self-surrender, so he's going to continue to earn a good income until he was incarcerated. And certainly the district court also knew that once the defendant was incarcerated, his monthly income would be drastically reduced as a result of that, and factored that in to the overall analysis of what the proper fine should be. Finally, I think it bears mentioning that the majority of the defendant's reply brief focuses on his belief that a fine was not appropriate in this case. But in front of the district court, he never argued that he was unable to pay a fine. Not in his objections to the PSR, not in his sentencing memorandum, and not at the sentencing hearing. The very first time he made that argument was before this court. And that is truly a frivolous argument because his net worth at the time of sentencing was approximately $143,000. Now, it's true that before the hearing, the parties agreed that an additional $31,000 restitution was appropriate, and that was ordered. And of course, the district court ordered a $10,000 fine. But if you do the math, as Judge Malnaugh did, he still had over $100,000 in assets after the fine and after the additional restitution was considered. So in summary, the record clearly shows that the district court did not rely upon the incorrect net worth amount in the PSR when it imposed the $10,000 fine, and therefore there was no procedural error here. So unless the court has further questions, I would just end by asking you to affirm the judgment and conviction order of the district court. Thank you.
Thank you, Mr. Wagner. Mr. Hillis?
Feels almost that the government's willing to shift the burden to us to say that once we object in the PSR, we have to say more to the district court to have itself on record about what the correct figures are. We don't have to do more. Once we state what our position is, it's for the district court to make determinations under Rule 32 at the time of sentencing. They can't point to the complete absence of a resolution and say this supports our position that there was a determination and the right figure was used throughout. We would expect district courts to be using information from the PSR to make its determinations, and when it is incorrect, it is common for district courts to say, I'm amending the PSR and direct that it be done so at sentencing. This is not an uncommon event. This is how we know that the district court is operating with the correct universe of facts. That didn't occur here. So far as liabilities go, when the government says the district court's PSR correctly listed the liabilities, even at the time of sentencing, once you agree to pay an additional $30,000 in restitution, that's an additional liability that ticks the number down. Now, I expect the district court may have been conscious of that, but it would have been better to refer to it to get a handle fully on what the amount is that my client had. And then as for my client's lack of objection to a fine, we know from the Martin cases and plenty of others that once the sentence is imposed, you don't have a duty to stand up and object to the imposition of the sentence. That includes the fine. So if it wasn't on anybody's radar that a person with limited assets would be expected to pay a $10,000 fine, then especially with the fairly helpful efforts by my client to pay restitution of first $150,000, then the $31,000 that he agrees to be tagged with another $10,000 at the end of it, my client isn't going to stand up and object, and he doesn't have to under Martin. Rather, what has to occur is a correct determination under the law, 3572B, that this $10,000 is warranted in light of future earnings, existing assets, considerations like that. And then most importantly, I would say, under circumstances like this where the government is now asking for a $10,000 fine, take a hard look at whether or not that is consistent with 3572B and my client's ability to pay restitution when the government wants to collect first a $10,000 fine. That is not in keeping with the factors either so far as earnings and worth that my client has, as well as the impact that the $10,000 has on his ability to pay now the additional $31,000 in restitution that he agreed to at the time of sentencing.
Thank you, Mr. Ellis. The case will be taken under advisement. Thank you to counsel. Our final case of the day is Martinez versus Bondi. Mr. Budzinski, whenever you're ready. Hold on, let's let Ms. Roberts kind of get settled in here. Okay, go ahead.
Good morning, Your Honors. Budzinski for petitioners. two issues in this case: whether substantial evidence supports the agency's conclusion that petitioners did not establish that the Honduran government is unable or unwilling to protect them, and that petitioners could not reasonably relocate in Honduras to avoid harm. Beginning with unable or unwilling to protect, the agency reached its conclusion because Martinez never sought assistance from the police, because Honduran authorities investigated, prosecuted, and imprisoned some of the people responsible, and because Celio Rodriguez is wanted in Honduras, although he has been on the run for about a decade now. The agency also contended that the country conditions evidence, which indicated that Honduran efforts to combat this violence was inadequate, was outdated.
Did your client raise either of those issues before the Board of Immigration Appeals?
Yes, I believe so, Your Honor. Their arguments vary to some extent with the arguments raised here on appeal, but the larger issue was raised on both of those. First, that Martinez never sought assistance from the police is immaterial. Authorities were already aware of this violence and ostensibly investigating. Martinez explained that the police would come, but they never did anything. The country conditions evidence corroborates this claim that these investigations were a sham. It doesn't make sense to seek assistance from the police when they are already aware of the violence and ostensibly investigating. Additionally, it would have been futile under the circumstances. Again, the investigations were a sham, and reporting persecution is not required when it would be futile. Second, the Honduran authorities were eventually able to apprehend some of the perpetrators, is undercut by the fact that others remain at large, including the primary perpetrator of this violence, Celio Rodriguez. Additionally, the violence has not stopped. There was another murder as recently as a year before the petitioner's merits hearing. The same can be said for Celio Rodriguez. While he is wanted in Honduras, the inability of authorities to apprehend him, the primary perpetrator of this violence, for about a decade now is telling. On the purportedly out-of-date country conditions evidence, the article in question is from 2014. Petitioners left Honduras in 2016, and the violence that petitioners experienced occurred reasonably close in time, around 2015. The contention is also undercut by the fact that the Department of State report indicates that the violence continued, although far below its peak. And it's also undercut by Martinez's testimony to the same effect, including a murder a year before her merits hearing. That the primary perpetrator remains free, and the fact that the Department of State report indicates that the peak occurred in 2012, before the 2014 article, and before the violence that petitioners experienced. Indeed, all of the violence that they experienced occurred after this peak. Turning to internal relocation, the agency reached its conclusion on this issue because Martinez's decision to be a part of this organization, MUCA or MUCA, and live at La Confianza was purely voluntary. Because Martinez's belief that she would be targeted anywhere was not reasonable, and because she cited only one incident in which someone was killed outside of La Confianza, and because this person killed had valuable information about the criminal activity of Celio Rodriguez and his associates. Additionally, because Martinez has family members still in La Confianza. Beginning with the voluntariness of her membership in this organization, it is inapposite to the issue and not accurate. It's inapposite to the issue because even if Martinez can physically leave, she would still be a target due to her past association, her opposition to Celio Rodriguez, and her knowledge of their activities. This is what happened to Henry Armendariz. He left, they followed or sent someone to San Pedro Sula, and they killed him. It is inaccurate because Martinez had to join the organization because there was no other work available to her and she had nothing to eat. Martinez explained as this is why she would not be able to go work somewhere else. Being a part of this organization is not voluntary if you have to do it to survive. This also goes to the reasonableness of relocation. That is, it's not reasonable to expect Martinez to relocate if she cannot find work elsewhere. The immigration judge did not address reasonableness, and the internal relocation inquiry is really two: whether relocation would be successful and whether relocation would be reasonable. The immigration judge only addressed the former. On the immigration judge's contention that Martinez's belief that she would be targeted anywhere was not reasonable because she only knew one person killed outside La Confianza, one is enough to make it reasonable. They killed someone outside of La Confianza, they can do it again. On the immigration judge's related point that Martinez is not similarly situated to this person because he had valuable information, Martinez also has valuable information. This was obviated by her testimony. She testified at length about their criminal activities. On the immigration judge's last concern that Martinez has family in La Confianza who have not been harmed, as mentioned, Martinez has information about Celio Rodriguez and his associates. Additionally, she previously had a confrontation with one of Celia Rodriguez's associates, and prior to her departure, people were seen looking through the windows of her home. Respondent argues that petitioner's argument regarding the voluntariness of Martinez's membership in the organization merely goes to weight, is belied by her testimony that she could leave it, and that economic hardship is just one consideration. First, it doesn't go to weight. Petitioners are arguing whether she could leave is inapposite to the issue, that it does not matter whether she could leave because she would still be targeted. On Martinez's testimony that she could leave, both the immigration judge and respondent are conflating whether she's permitted to leave the organization or whether leaving is something she could realistically do. And realistically, she cannot because she would have no other way to provide for herself. Respondent also addresses petitioner's use of the word enough in their brief as it relates to Henry Armendariz being murdered outside of La Confianza, arguing that petitioners are disputing evidentiary weight. No, here they are arguing that the immigration judge's conclusion that it would not be reasonable for Martinez to believe she could be harmed outside of La Confianza is not supported by substantial evidence because Henry Armendariz was killed outside of La Confianza and Martinez is similarly situated. If there are no questions, I will reserve the remainder of my time for rebuttal.
Thank you. Ms. Roberts.
Thank you, Your Honors. May it please the Court, Roberta Roberts on behalf of the United States Attorney General. Substantial evidence supports the agency's dispositive, able and willing and internal relocation findings, and record evidence does not compel a contrary conclusion. First, petitioner's arguments to this court are unexhausted and therefore should not be considered. And because petitioners failed to exhaust challenge to issues dispositive of their claim, the court should deny the petition for review. Second, even if the court were to consider these unexhausted arguments, they fail on the merits. For example, addressing petitioner's unexhausted, unable, or unwilling argument, the record does not compel that the Honduran government was unable or unwilling, or is unable or unwilling to protect the petitioners. In this record, both petitioner's own testimony and as seen in the 2018 State Department Country Conditions Report, we see that the Honduran government created a task force to address the violence in this specific area, the Bajo Aguan Task Force. They had transnational coordination with Mexican law enforcement authorities and Interpol to arrest and extradite Osvin, the main hitman who petitioner testified about being afraid of. The Honduran government took extensive measures to bring Osvin to justice. As mentioned, a task force was created. Transnational coordination with Mexican law enforcement authorities and Interpol to arrest, extradite, prosecute, convict, and imprison this person. That shows that the Honduran government is both able and willing to protect petitioners. Indeed, petitioner herself testified that not only was Osvin imprisoned, but several other members were imprisoned as well. So this shows that petitioners are not able to meet their burden of showing that the record compels a contrary conclusion. Indeed, the record shows that substantial evidence supports the conclusion that the Honduran government is able and willing to protect petitioners. Briefly, I'll note briefly to keep it short, I'll note one additional point, that petitioners say that one of the ringleaders, the mastermind, is on the run, and that demonstrates that the Honduran government is not effective in its protection. However, one, it shows that because this person is on the run instead of committing additional crimes in Honduras, that further shows the effectiveness of the Honduran government, and that they are not unable or unwilling to protect petitioners. In fact, the murder that was the most recent murder from 2018, 2018 was also the year that Osmond, the main hitman, was captured and prosecuted, and petitioners did not testify to any other murders that occurred after this transnational effort with Interpol. Petitioner's hearing was in September of 2019, and the most recent murder that she testified to was in 2018. And finally, as case law says in the circuit, for example, Osorio Morales v. Garland, it says here that this court has upheld rulings that a government is not unable or unwilling to protect its victims from persecution where the record reflects that the government has taken some steps, even imperfect ones, toward protecting victims. And in this case, the government has taken not just some steps, but extensive steps to protect those here. So even addressing petitioner's point about one person still being on the run, that is not enough to meet the burden to say that the record compels a contrary finding to what the agency found.
Ms. Roberts, with regard to the relocation issue, does the agency take into consideration whether a particular individual can or cannot find employment in a particular region of the country in determining whether or not relocation is reasonable?
Yes, Your Honor, that is a consideration that is taken into account. And also, it is the petitioner's burden to provide evidence of any difficulties that they may or may not have in finding employment in the country of relocation, especially because, as petitioners emphasize, they are not seeking a past persecution claim, but a future persecution claim. So they have the burden of proof in demonstrating that internal relocation would be unreasonable. And unfortunately, in this case, they did not meet that burden.
She did say that she doesn't think she can get employment in other regions of the country, right? Is that not enough?
That would not be enough because petitioner, for example, did not provide any evidence as to why she would not be able to obtain employment in another area of the country. Is there any particular characteristic that she has, or some type of skills that she has or does not have that means that she cannot obtain employment in another area of the country? These are things that are on the petitioner to bring, as petitioner is the one who has the burden of proof and demonstrating those things. And because petitioner did not do that in this case, petitioner also, that is another independently dispositive issue that petitioner did not meet their burden on. So on both the unable and unwilling issue and the internal relocation issue, petitioners failed to meet their burden, and therefore respondent would argue that for the reasons stated today and in the brief, that the petition for review should be denied, unless Your Honors have any additional questions.
Thank you, Ms. Roberts.
Thank you, Your Honors.
Mr. Brzezinski, anything else?
On exhaustion, in UV Escondido, the Supreme Court tells us that once a claim is properly presented, parties are not limited to the precise arguments made below, and any argument can be made in support of the claim on appeal. Turning to unable or unwilling, again, others remain free, violence continued, and while Celio Rodriguez was on the run, more crimes did occur. Again, another person was killed in 2018. And if there are no questions.
Thank you. Ladies and gentlemen, that concludes the arguments for today. The court is in recess.